All rise. Hear ye. Supreme Court of Florida is now in session. All we have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is the Florida Bar versus TIKD Services.
May it please the court, my name is Chris Altenburn. I'm a member of Banker Lopez Gassler, and I'm here today as co-bar counsel with Ms. Vasquez and Mr. Spilius for what is effectively the final hearing in an original proceeding alleging that TIKD Services and Mr. Christopher Riley are engaged in the unauthorized practice of law. The question here is whether TIKD, which is neither a law firm nor a lawyer referral service, what we now call a qualifying provider, is practicing law by giving advice, legal advice, in its advertising and offering to provide legal services to the public on its website. Specifically, whether it's offering to provide traffic ticket defense services for courtroom challenges.
Let me ask you this. Just walk through for me. Let's say I get a traffic ticket and I want to fight it or whatever, and I hire these services. I contact them. Walk for me. What is it I do at that point in time? Who do I pay? How do they distribute the money? Just walk through for me.
Well, and what happens is they tell you that they have this statistical model that they use. They take a picture of your ticket and they run it through a statistical process that's much like what a casino would use, and they give you a price for your ticket. And what they tell you is that if you do this quote-unquote better solution for challenging...
Is the price standard? Is it always 80% or is that not so?
I don't think the record establishes that, but it's a percentage, and what it's based on is that and I'll jump to that part of their website. They tell you how this works. We can do this because we already know what's going to happen. Maybe not with your particular ticket, but on average. Many tickets are either dismissed or result in reduced fines. Since TIKD handles so many tickets, we know with a pretty high degree of certainty what is going to happen to a particular ticket and therefore how much it's going to cost us. As they say, this is the law of large numbers. Now what TIKD really knows is the probabilities that a traffic case will be dismissed. Many of them are dismissed because the law enforcement officers are the prosecutors and they don't show up for court. Their method is a super secret trade secret, but frankly, the uniform statistics for traffic are public records that are available on the internet for every year, every county, and every type of ticket. Anybody with an Excel spreadsheet and a little bit of math knowledge can do this and figure out what the odds are.
So say, could you get back to answering his question?
Let's say the ticket for my offense is $100. So I give them $80.
Right.
What happens to that $80? Walk it through the whole process.
That money goes to TIKD. It does not go to a lawyer's trust account. And a portion of that money, and the contract is sealed in your court record, so I can't tell you the numbers in open court, but a portion of that goes to the lawyer, and TIKD keeps the rest, and their promise is that they will pay your ticket if you get a ticket. They will pay your ticket and give you the money back if there's points on your ticket. And basically, you spend 2 minutes doing this on your phone or your computer, and you're done with that. You know, they advertise that you get all the benefits of a court challenge along with the convenience of simply paying your fine. No court, no phone calls, no hassle, right from your phone in 2 minutes or less. And if you do that, what they're telling you is you avoid points on your license and thousands in higher insurance costs. Now, if you don't go with TIKD, go somewhere else, you're going to have points on your license and an increased insurance cost. Always pay the full amount, no ability to pay the fine over time, and the hassle of hiring your lawyer. Now, Mr. Riley says in his affidavit he's not giving legal advice on his website, but this is answering many of the same questions that lawyers answer for their clients once they know the facts of a traffic ticket. This is very clearly legal advice. So why is it then that he has this emphasis on no court, no phone calls, no hassle? If you look at the frequently asked questions, he even says, you might get a notice from court that your hearing is on a certain date, but you don't really have to go. It's because of that statistical model that they are running that all TIKD has to do is beat the spread. They know that as long as the lawyer does nothing that interferes with the random odds of what they're doing, that they make money. But if this person actually goes to a lawyer, the hassle of a lawyer, and asks about this, the lawyer's going to tell them that almost all of this is misrepresentations, and some of it is just flat false.
But I'm sorry to interrupt you, but you're ignoring the fact that the second part of this is that they are connected to a lawyer. They do enter into a relationship with a lawyer, and then that lawyer can give them whatever advice that, the two parties think is necessary.
Well, yes and no. Again, if you look through the website, they are being told they will be to this lawyer, but they're then being told you don't have to call him, you don't have to go to court with him. We're automatically, I guess, telling him to plead not guilty.
But there's nothing in the record that suggests that there isn't an actual contact with, as part of the business model, because obviously we don't know what might happen in any given situation, what a person might choose to do as far as how much contact they want. But the way it works is they are connected to a lawyer, they enter into a separate relationship with that lawyer, and then it's up to them how much interaction there will or won't be, right?
Yes, but TIKD is still the one who is selecting the law firms to go to.
Which is just like what an insurance company would do.
No, absolutely.
And the company can, the person who wants this service can reject the lawyer, right? They can get their money back.
But I really would like to emphasize it's not the same, because TIKD has to carefully have a lawyer that meets their statistical model. Because if this lawyer comes to them before trial, manages to meet with them before trial despite the meager amounts that TIKD is paying this lawyer in the sealed contracts, and realizes that this person has points and an opportunity to go to traffic school. If you go to traffic school and pay the clerk, you're guaranteed to get an 18% discount on the ticket. You're guaranteed not to have an adjudication. You're guaranteed to have no points on your license. But TIKD doesn't say that any place on the website, because if they know that, if the client knows that, they can't use this casino-like model to make any money. That takes away from this. So they're giving advice while hiding the advice that a lawyer would give them if there was really the full contact with a lawyer.
Could you elaborate on that? Because I think it's hard to separate sort of all the parade of horribles about the business model versus the law, which is the quote-unquote practice of law. So could you be as specific as possible about what it is that's going on here that would constitute the practice of law? Because when I read our cases, it seems like what the court has been focused on is people getting advice, potential clients getting advice from people who the client believes would have a certain amount of skill and knowledge, et cetera, and the person who's giving the advice, because they're not a member of the bar, may or may not have that information. And so it seems like this model is set up specifically to make sure that there is that relationship with a member of the Florida Bar who would presumably have the skill and knowledge and whatever. And so I'd like to know as specifically as possible what it is that you say the company is doing that constitutes the practice of law.
And this sort of boils down to whether it makes a difference whether the lawyer is on contract, as in we the people, or whether this independent contractor relationship makes a difference. And what I would submit to you is that when you go back to Sperry and the tests that we have created for giving legal advice or being the provider of the lawyer, the question is, do you need to have legal knowledge to be giving them advice? This website is giving them advice to plead not guilty and go to court without any specific fact basis at all.
So what you're saying is the practice of law is the quote-unquote advice that's on the website?
Two things. The advice that's on the website is legal advice. It's being given by a non-lawyer to convince someone that they want to plead not guilty and challenge in court. That's legal advice. But more importantly, they're providing lawyers. And they're providing lawyers that are not on their staff, but they're contract lawyers with TIKD. So TIKD, because it knows the statistics, will know which lawyers are making money for TIKD by not having their clients pay money in and who are not.
But in terms of sticking to the record, unlike our past cases where the court found that there was, the non-lawyer company was essentially controlling and directing the work of the lawyers, and that's what gave them pause. That's what sort of supported the conclusion that that was the practice of law. In this case, there's nothing in the record that suggests that this company is directing or controlling or telling these lawyers what to do. Obviously, there's a financial element here that because of the rates that they're being paid, that may imply a certain amount of work. But as far as sticking to the record here, there's nothing that says that this company is telling the lawyers what to do.
But what we stick to the record is it shows a business model that they explain on the record that is inherently at odds with the best interests of the client. And it seems like we're sort of blurring. There's a sense in this case that people are uncomfortable with the amount of regulation that this company is subject to, which seems like that's a different question from what we have to decide, which is whether this company is quote-unquote practicing law. Right.
Go ahead, I'm sorry, go ahead.
I'd say one of the reasons we regulate advertising and the like is that no lawyer or legal service could come close to putting this stuff on the website. And so I would submit to you that the test isn't whether the lawyer is directly contracting with TIKD as an employee. That's not his employment status, but whether the lawyer's business relationship with the non-lawyer, with TIKD in this case, combined with the non-lawyer's business relationship with their mutual client, is a structure that adversely affects the quality of the legal services provided to the public.
But why is that the question, counsel? I'm sorry to interrupt you. So we're starting with a situation where if we read the Constitution, the Supreme Court shall have exclusive jurisdiction to regulate the admission of persons to the practice of law and the discipline of persons admitted, right? That's the source of our authority. In Sperry, which involved an unlicensed practice of law situation, the court said, quite obviously, this matter now before us does not involve either the admission of an applicant to the bar or the discipline of one already admitted. So we're already talking about but for us being in this business at all, it's a fairly tenuous connection to what our actual constitutional authority is. And so it seems like we need to be cautious we need to be fair about what we're saying is the quote-unquote practice of law, because that's really the only thing that we have authority over. This question about new business models and all that, I mean, the legislature has a statute on the unlicensed practice of law. We have an attorney general who can protect consumers, et cetera, et cetera. So don't we need to keep the focus on really carefully looking at what this company is doing and whether that is the practice of law, as opposed to sort of conjuring up all these potential problems with advertising and the business model, et cetera, et cetera?
If you're going to allow non-lawyers to do all the advertising that we regulate by the bar, I submit to you that you have just given the private people a substantial part of the practice of law. And that when you look at this, and I understand why you want to keep it narrow and there should be a free market for ideas and for business. But in this situation, what you're seeing is a situation where they are telling people on the internet that they will do all of these things, that unless these people actually go to the lawyer that they're told not to call and not to phone, they're never going to know that what TIKD is telling them on the website is totally false. That in fact TIKD is the one that if the officer shows and they got 10 points on their ticket, they just lost their license, they probably will lose their job, and TIKD's terms of service say they can arbitrate and get $100 for that. And I mean, I submit to you that they are giving lots of legal advice here, and that on the face of this record, that legal advice is harmful to the public. And that has been the test since Sperry. So if you want a receipt from Sperry, that's one thing. I'm sorry.
Mr., you have used, or maybe it's more accurate to say, most of your rebuttal time has been consumed.
All right. Well, let me just say.
But what I'm going to say, it's going to all be gone in 5 seconds here. I'll let you have the 3 minutes anyway.
Thank you.
Okay.
I'd used all 15. The light never turned on. Or if it did, I didn't see it.
When it goes yellow,
All right.
you're in rebuttal. So.
Thank you.
1040 Scan automates 4 to 7 times as many tax documents as the competition.
Good morning. May it please the court. My name is James McGuire with Thomas & LaCicero, and we represent the Amici, the Florida private practice lawyers. And first, I'd like to thank the court for allowing us to participate in this oral argument today. Obviously, from what we've heard so far this morning, the key focus of this case is TIKD engaged in the practice of law in some manner that this court has oversight over? And I think that perhaps the initial way to address that is to think about what is it that TIKD sells? If you remove the lawyers going to traffic court from their basket of goods, they're not selling anything. They have nothing else to sell. The only reason they have clients is because they say, we're going to get somebody to go into court for you. That's providing legal services. Now, there's a question, of course, whether that's appropriate to do that, but that is the one and only thing they sell. Everything else is bells and whistles.
Well, and doesn't that, the point you're making there, fit in with what we said in Consolidated Business, where although we talked about, and we basically adopted what the referee said, but there was a lot of focus on the various ways the lawyers were controlled. But in addition to that, the referee said the respondent has shown no other means of producing income other than by the providing of legal services, which clearly is a practice of law. Were the respondent to cease providing such services, then it would cease to exist as an income-producing enterprise. The nature of the corporate business is such that it must be deemed to be engaged in the unauthorized practice of law with or without the examples of lay control. So I think that stands for the proposition that if a business entity derives all of its income from the practice of law, it is engaged in the practice of law. I don't know how else to understand what was said there.
Your Honor, I could have spent very little time preparing for this case and just allowed you to say that. I think that's exactly right. And in that same case, Consolidated Business, this court also reminded the parties of the old admonition that you cannot serve two masters. And in this case, if you are a lawyer contracting with TIKD, you are absolutely serving two masters, because TIKD has one and only one goal when its lawyers go to court. That is to avoid a fine. Now, for some drivers, that's perfectly fine. That's what you're looking for too. Best case scenario is avoid the fine. But for some drivers, if you go in, just for example, and you've already got 10 points on your license, and you get convicted of a speeding ticket, you're going to get 3 more points, which means you now have 13 points, which means your license is going to be suspended. for that individual, going in and trying to defeat the ticket may be the dumbest thing you can do.
But isn't the whole point of that, though, that the person then gets connected to a lawyer who can talk through all that with them? And to the extent it doesn't happen, I mean, that's your client. I mean, you can talk as much or as little with your lawyer as you want.
I guess I would say in a sort of academic sense, that's absolutely true. I can't argue with that. But, you know, part of the purpose of us being here as amici in this case is we do have a little real-world experience both with TIKD and with defending traffic tickets. And when the system is set up and the website keeps saying, here's how this is going to work, we're guaranteeing you all these things. If you don't use us, you're going to get points on your license, you're going to get all these other terrible results. You've basically already been told through the legal advice of TIKD, this is the best way to handle my ticket. TIKD has got me covered.
But if that's the issue, then it seems like we've got two things going on here. We've got sort of the fundamental question about whether the business model is inherently the practice of law. And then we've got something that's really, I mean, I'm not sure I don't know about whether that constitutes legal advice or not, but that's easily fixable. I mean, if that's the issue, you know, if the website said, hey, we're going to connect you with a lawyer and we encourage you to talk to them to talk through all your options, then all of a sudden magically that's no longer the practice of law, right?
I don't think so, Your Honor. I mean, I think if you read through that website,
well, no, but I'm just saying, I mean, let's assume that the website can be changed. If the point is, if you're saying that it's quote unquote legal advice, that this discourages people from actually talking to the lawyer, that's something that's easily fixable, and then you would be left with the question of whether the business model is inherently the practice of law, which I think is what the Chief was suggesting with his question.
I suppose it's fixable in the sense you've mentioned that you could simply revise the language on the website. But I think if we're looking at this from a real world perspective, TIKD's business model, what it's doing, can't work if the lawyers have to spend time with the clients. They pay them so little. This is all about running through the numbers and generating as many of these as you possibly can. That's the reason why TIKD's business model will only work in a handful of counties in Florida. It'll work in Miami-Dade because there are so many tickets, there are so many lawyers, there are so many people challenging the tickets that the court is overwhelmed, and so a lot of them get dismissed. If you go to a small county, if you go to Manatee County, it'll never work because the lawyers are going to have to spend too much time and they're not going to win enough of the cases. This is all based on, to take the bar's analogy, it's a casino sort of process. The house has to figure out the odds. And if the odds are in the house's favor, then blackjack is fine. We can play that. If the odds are not in the house's favor, then that game's not going to be available.
You're now about a minute over, so you can sum up in 15 seconds.
Well, apologize. I guess I would just leave you with this thought. If I, as an attorney, set up my own business, called it Jim's Ticket Defense, and did all the things that TIKD is doing, I'd be in significant trouble with the bar. And the odd thing is, if I ended up in front of this court and got disbarred, in TIKD's world, hooray, everything's now resolved. I'm not a lawyer. I no longer have to abide by any of the rules that govern lawyers. I'm better off being a disbarred lawyer and doing this than being a lawyer and trying to run the exact same business they are. And I think in that world, what they're doing makes no sense.
Well, but if the lawyer, I mean, TIKD is contracting with lawyers. Lawyers are entering into these contractual relationships. If they're not serving these people well, they're subject to the discipline of this bar, right?
They are, Your Honor. I guess what I would say to that, though, is that, you know, traffic tickets occur at that sort of margin where the expense involved, and you're not going to get sent to prison, you're not going to get $1 million judgment against you, the sort of things where people will spend their life savings to defend themselves. If things don't go so well for TIKD, those people will probably look at the website and say, I'm limited to $100, plus I got to pay an arbitrator to look at this case. What am I going to do? Walk away from it. I mean, I think the thought that people who are using TIKD to help them with ticket defense are then going to go hire a private practice civil attorney to sue the first lawyer about how the ticket was defended.
But that's probably true if they had walked in off the street to another lawyer offering the same service. I mean, the incentives don't really matter in terms of how you got connected to the lawyer that you ended up using.
I agree, but I cannot lie to my clients or my potential clients online in order to get them in the door. TIKD can do that.
We're going to need to move on here. Unless somebody else has a question.
I apologize,
Okay.
but thank you. Obviously, we support the bar's position.
Thank you.
May I please the court, Christopher Kais on behalf of the respondents. The focus of UPL regulation is on preventing harm, not protecting monopolies. TIKD represents the efficient intersection of technological innovation and access to counsel. There is no evidence of harm in this record. Despite everything you've heard, it's all hyperbole. There's no actual evidence of harm in this record. And it is undisputed that all legal services delivered to TIKD customers are provided by licensed, independent Florida attorneys. This is what an access to justice solution looks like. The bar spends a lot of time and has a lot of committees that talk about access to justice. Let's find a way to make legal services more accessible to the average individual. And the only people that have an incentive to do that are not the bar, they're not the amicus, they've got their own monopoly. It's technological innovators.
I'm sorry to interrupt you, but could you address the issue that the chief raised about whether we would be extending the logic of the case that he mentioned by applying it here, or are there, essentially he was suggesting in his question that the business model issue has already been addressed by that case, and I'd be curious to hear what your answer to that is.
And I'd respectfully disagree with that, Mr. Chief Justice, because TIKD is in the business of selling an administrative platform and in the business of selling the financial guarantee. That's what the referee found. The referee found that's the business they're in, and the referee found that it doesn't provide or offer to provide legal services. It provides access, not the services. And so the fact that it is connected in some way to the legal profession doesn't thereby render it.
Let me ask you about that. If someone is stopped by a law enforcement officer of a governmental agency and is charged with a traffic offense and given a notice to appear in court, you would agree that they have a legal problem and only a legal problem, correct?
They do have a legal problem, yes, Your Honor.
And wouldn't you agree that you're offering to solve that legal problem for anybody in that circumstance?
We are offering to provide the administrative support, to provide them a financial guarantee, and to provide them access to a licensed independent Florida attorney with whom they contract separately.
You say in the advertisement that's attached as Exhibit 3A to the bar's response to the motion for summary judgment that you get all the benefits of a court challenge if you resolve your legal problem with TIKD, but you'll get points on your license if you go with an attorney. You won't get points on your license if you don't go with an attorney. You give all the benefits of how coming to your client to solve this legal problem is a better idea than going to a lawyer. Is that accurate?
I would disagree with it to this extent, Your Honor, and that is it's not that you're getting all the benefits coming to TIKD and not going to the lawyer. You're coming to TIKD and you're getting the administrative platform, you're getting the payment in one place, you're getting the administrative details, all of the public details about your case on the dashboard in a convenient place. You're getting the opportunity to access a lawyer in one place. You're getting the financial guarantee in one place, but you're still getting
a law firm could say all of those things, but if a law firm advertised the opportunity to address someone's legal problem, they would have to have that advertisement approved by the Florida Bar, and it would be subject to regulation so that it could not be misleading, correct?
Yes, Your Honor.
Okay.
They would.
Why does it make sense that a lawyer, isn't that necessary for the protection of the public, that a lawyer cannot mislead the public in advertising to solve a legal problem?
Well, there is no lawyer that's misleading the public, one. Two.
Right, but you are.
I don't.
I mean, your client is, and this advertisement that's attached as Exhibit 3A.
I would respectfully disagree. I mean, I appreciate your characterization, but I would respectfully disagree with that. I would again say that what we're doing is we're connecting them to a lawyer, and that lawyer can give them legal advice. And if there
It says with TIKD, you avoid points on your license and thousands in higher insurance claims. Without TIKD, you will get points on your license.
if you just
Isn't
pay
that
the ticket,
misleading?
though. If you just pay the ticket.
It says that, doesn't it?
It says that.
Does
It
it
does
say
say
that?
that. It
Okay,
does
it's
say
not a question of whether you would say something different. That is what your client has said. Isn't that correct?
That is correct, Your Honor.
So if we regulate lawyer advertising to protect the public because it is damaging and harmful to the public to mislead them in offering to solve a legal problem, why isn't offering legal services to the public an integral part of the practice of law that needs to be regulated in order to protect the public?
I just don't know where that would that proposition would end then, because anything then that's connected to the practice of law, any sort of advertisement, any sort of business model that provides greater access to counsel is going to be subject to that theory. And so if we're here about what is in the advertising and changing the advertising will change the outcome, then that's something that could be readily addressed. But that doesn't make the business model something that constitutes the practice of law. The focus of this court's cases, the core of UPL regulation is who is giving the legal advice, who is actually rendering the legal advice. And here it's an independent, licensed Florida attorney that contracts separately with the client.
And counsel, you would agree that, I mean, there's no business, it doesn't matter what business you're in, whether it's the legal business or any business in Florida, a company can't engage in misleading advertising. I mean, isn't the question what legal regime that the advertising would be subject to, not whether, it's not as if we say this is not the practice of law that then these ads can say whatever they want and there's no legal recourse. Isn't that right?
I think that's exactly right, Your Honor, and I think that's exactly what the bar recognizes in its comments on the Rule 23 that it's proposed. In response number 1 that we've attached as in our notice of supplemental authority, the bar has proposed a rule, Rule 23, which essentially adopts exactly what TIKD is doing. It says that you can have an online service provider that matches lawyers with clients, that sets the fee and collects and remits the fee, and that's really what we're doing. And so in the context of the advertising, yes, as the bar recognizes, and as you pointed out, Justice Muniz, there's the Deceptive and Unfair Trade Practices Act, the Attorney General's office.
Well, but isn't the one thing that sets us apart from other things that and I understand you don't think it's misleading, but assume it's misleading. It is misleading in providing legal advice. It provides misleading legal advice, which seems to me to get us over into the unauthorized practice of law.
Again, Your Honor, I respectfully disagree because the referee found that TIKD does not, I mean, these are the facts in the record that's fully developed, and unless this court is prepared to say, which they might be, it's your prerogative, that they're clearly erroneous or wholly contrary to the evidence, TIKD is not practicing law. They're providing the access. As soon as that client gets to the independent lawyer has an obligation as a member of the bar to provide legal advice.
How does TIKD ever reject cases?
We reject a lot of cases, yes, Your Honor.
And the basis for accepting a case or not accepting a case, what is the basis?
So it is a mathematical probability analysis. So to answer the question that you began with, Justice Labarga, I get stopped. I get a traffic citation. I don't have my iPhone since they took it at the front, but I would go on that device and I would take a picture of the ticket and I would upload that to TIKD, and then TIKD would receive it. They would run it through their risk assessment model. They're mathematicians. They're innovators. They figured out how to harness the data, and they run it through their business model, and they determine that is a risk transaction they're willing to accept. And that is what I'm saying. The administrative platform and that risk transaction, that's what they're getting paid for, not getting paid for delivering legal services. If they accept the ticket, then they say, let's use a $200.
What is the client told? Let's say I call your service because I got a ticket, And am I told, well, we need to analyze this, and then we'll let you know whether we take your case or not?
It takes seconds in the computer world. You get your answer within a minute or less.
But is there anything in the brochure or in the advertisement or anything to the extent that you're going to be selective about the cases that you take?
Yes, I believe so, Your Honor.
So if I'm a client and if I'm a person with a traffic, not that I ever gotten one or anything like that, and I see an advertisement that says, without TIKD, you'll get points. With us, you won't. And then you're being selected about whether you take my case or not. Why would I not? My rationale would be, well, they have already pretty much done their thing, and I'm looking pretty good. They're going to send me to a lawyer, and I'm going to beat this. Why is that legal?
What they're saying to the customer is that we are willing to take on the risk associated with the transaction, but that's not rendering legal advice. And it's very clear, in this record, there is not a single, the bar has had 2 years plus to introduce a single instance where any TIKD customer thought TIKD was a law firm or rendered legal advice. There's not a single instance of that anywhere in this record. And all of the hobgoblins and all of this, this advertising and so forth that counsel have pointed out to, why is there no evidence in the record of harm? That is sort of the core of UPL regulation. Harm being visited upon a consumer based on unskilled or unqualified practitioners. And so the language of the advertisement, again, we can disagree as to its import, but there's no record of harm, there's no record of market confusion, there's no record of anyone thinking TIKD is a law firm, there's no record of a complaint by any TIKD customer.
Let me ask you this, if this is perfectly fine and not the practice of law, what would be different from coming up with an app that offered to handle a divorce for a flat fee? And then contracting with the lawyers, you accept the cases, you have them put in the information, how much is at stake, are there children, and you figure out that your firm can handle this and make a profit because you know that you have lawyers you can contract with that'll handle it for a flat fee. So isn't that exactly the same thing?
I think that the hypothetical, no.
Why not?
I think because the hypothetical doesn't include enough facts to make that decision. And I'm not dodging you. I'm not. What I'm saying is that each UPL case, and this is part of this court's jurisprudence, each UPL case has to be measured on its precise facts. So I don't think that saying
the precise facts are you're advertising to solve legal problems for citizens. And you're taking the money and you're contracting with lawyers to do it. If that is a model that's okay, why can't any private company advertise to solve legal problems for citizens, hire a lawyer to handle it for the client and make a profit, and avoid the advertising rules, the trust accounting rules, and every other regulation that we have that otherwise would apply to a law firm if it did the same thing?
So 2 things. One, they could, as long as there's no actual legal advice being given and there's a separate independent contract with a licensed independent Florida attorney.
Well, but obviously there's legal advice being given. I mean, they're facilitating it. They're not giving it. Your position would be they're not giving it. They're just facilitating it.
Correct.
But I'm struggling with this issue, and I would ask you to go back to the point in consolidated business and legal forms. Now, I realize there's a lot of talk there about the exercise of lay control over what the lawyers are doing. But at the end of the analysis, the judge says, that really doesn't matter. This can't be fixed. So even if you put in, what we said there is even if you put in measures to ensure that the lawyers exercise their independent judgment, because this entity exists to provide legal services or to facilitate the provision of legal services, however you want to characterize it. This entity is there deriving all its income from the giving of legal services. It is the unauthorized practice of law. I mean, I'm struggling to see how we could, and let me say this. I am not entirely unsympathetic with your client's position. I think we need to be looking at things that we can do that will innovate and provide access. But I'm struggling with how we can authorize this without backing away from what we said in consolidated business.
Because I think there's a big difference, Mr. Chief Justice, between providing the services and facilitating the services, to use your words. I think that's the real key distinction here. In consolidated business, they were in the business of actually offering legal services. The employees were, attorney employees were directed and controlled. What TIKD is doing is no different than what an insurance company does all day long. They hire, the Arch case that's coming up after ours is an insurance company that hired a lawyer for an insured. It's no different. In fact, anyone that's dealt with panel counsel knows that insurance companies are quite involved in the representation. Unlike TIKD, they're very much involved in the representation and sometimes become quite onerous, at least in my limited experience. But it's back to this question of facilitation versus providing the services. And in consolidated business, there were 17 specific findings of control. There were specific instances of harm. This wasn't some hypothetical. If this sort of access to justice solution doesn't work, if facilitation doesn't work here in one of the most basic legal services delivery mechanisms that we have at the bar, I don't see how anything, respectfully, is going to work, because anything that gets anywhere close to the bar is going to be deemed, well, you're too close. And as Justice Gorsuch observed in the ABA resolution materials that we provided, it's time to think differently about this. We allow this with insurance companies. We do this with insurance companies, and we do that because as a bar, it benefits the bar. It hires a lot more lawyers. So why do we look at the rules differently when we're talking about the consumer? The old views restrict prices, raise prices, and restrict competition. And here, this is the perfect model of an innovative solution. And I respectfully disagree, but even taking your views on the advertising, there's many ways to deal with the advertising. That doesn't make it the practice of law. It doesn't mean that we're practicing law. All of the cases focus on who is delivering the legal advice. What advice are they rendering? And here, the record establishes that it's not TIKD. The terms of service make it clear. All legal advice and representation is provided by licensed independent Florida attorneys, not employed, controlled, or directed by TIKD. That's a finding of fact that's in the record. It's not an inference like the bar calls it. It's a finding of fact. That's what is happening here in reality. There's no evidence of harm, even given 2 years. The bar is coming before this court with the exact same arguments it made almost 2 years ago. In all of that time, there hasn't been any introduction of any evidence to the contrary. And the Rule 23, the proposed Rule 23, is, to me, the biggest curiosity, to put it mildly. Rule 23 that the bar is proposing, that interestingly amicus is against that as well, authorizes exactly what TIKD does. It allows the online service provider, which TIKD would be, to match a lawyer and a client together. It allows them to set the fee, and it allows them to collect and remit the fee. That's what TIKD is doing. Now, the only differences are that the bar has inserted at the end, and this would be our issue with Rule 23, that they have the absolute discretion to say, yes, you qualify, or no, you don't. And so that seems problematic in a free marketplace, and to Justice Muniz, your points about the constitutional limitations on the authority of the bar. But the point of Rule 23 and what it demonstrates, and why we brought it before this court, is that it's demonstrating that the bar thinks this conduct, what TIKD is doing, is okay. And again, if there's issues with the advertising, well, then so be it. Then we'll deal with those either on an individualized basis, or the Attorney General's Civil Enforcement Office will deal with it, or some other mechanism. That's exactly what the bar has said, again, in its response to the comments by amicus in this case, that this is opening the door to false advertising. This is really a speedy, efficient, and relatively painless way to deal with the ticket, just as the referee found. The United States, according to the ABA resolution, ranks 103rd out of 126 countries in terms of affordability and accessibility of legal services. I would urge this court to adopt the position of the referee, to think differently. TIKD is an access to justice solution. It allows access to license independent Florida lawyers who are governed by the bar. They have professional responsibilities to those clients. The client contracts separately from them. TIKD provides access. It provides everything in one place. The public case details, it makes it simple. I mean, anyone that's had a traffic ticket knows that it can be a challenging process irrespective of how you deal with it. I mean, I just got a traffic ticket in Georgia not 3 or 4 weeks ago, and it took me 7 phone calls just to pay it. I mean, it's a difficult, time-consuming process, and so there are ways to make the accessibility of legal counsel easier and more affordable for the consumer, and there are ways to reduce the burden and time and expense. So I would urge this court, based on the uncontroverted record, to adopt the report of the referee and dismiss the petition. Thank you.
Let me cover at least 3 things very quickly. First of all, the notion that this comes to you with findings of fact that you can't reconsider. The referee in this case considered summary judgments. In fact, didn't even have an argument like this. She just ruled on the paper and announced it in open court. So you're here on a summary judgment, not on something that's been to trial with findings of fact by this referee.
Well, but the reason that's true is because the bar asked for it got sent to a referee, but then the bar didn't introduce any evidence, right? I mean, we have the record that we have because...
We have the record we have. On our motion, we had to prove that there was no question of fact they were practicing law. On theirs, they had to prove the contrary, frankly. And so that shifts me then, I think, to this next issue about harm. And your petitions under 10.7 of the rules do not require an allegation that specific harm has taken place. There's not a case that says that is an element of unauthorized practice of law. It's been an underlying policy behind this that we look to this to see whether there is a probability that there will be harm to the public. In We the People, for example, there's no discussion at all that Robert Norgard did anything that was malpractice or that organization did anything harmful to anyone, and yet we still declared it was unauthorized practice of law. So if you want to put harm as an element in this, you need to tell the bar that so they can plead it. But when we look at this, and as the demonstrations we've shown, there are people who should be paying the clerk who are losing their licenses undoubtedly if you do the statistics. Not everyone, but on average, someone's going to have that happen to them here. So there is, for summary judgment purposes, enough to establish harm here. And then finally, the comparison to insurance. Insurance is a regulated industry. You know, ironically, this came out of my printer yesterday right in front of We the People, so I picked it up. This is the statement of the insurance rights. We send out 100 of these in my law firm every week. And it's detailed, and it allows the client to have informed consent to this arrangement.
But that has nothing to do with the question of whether essentially pre-selling legal services, which is what insurance companies do, is the quote-unquote practice of law, which I think is what I think that's the point of their analogy.
But what their system does is conceals their contractual arrangement with the lawyer. And so they know, and the lawyer knows, that they have, if they're splitting fees, and they're splitting fees, they have to get informed consent to this arrangement from the client. And those contracts are sealed in your record. There's no way that this gets informed consent from a client. They are giving legal advice, and that legal advice is simply unauthorized.
That sounds like, if that's an issue, then it sounds like there should be an obligation on the part of this lawyer to disclose that. I mean, it seems like there's a lot of things that are being raised as potential problems with this that, if it's a problem, could be addressed through imposing. I mean, there is a lawyer here. Nothing is being concealed in the sense that the whole point of this is to, in addition to getting this, the technological help and the guarantees, that you're being connected to a lawyer who is subject to this host of duties that the bar imposes on people.
And going back then to consolidated business, the reason you made it unlawful practice of law was that the inherent danger of the intervention of laypersons into the attorney-client relationship. And this business model of TIKD does that. It is independent only on the surface because it ends up with a client who does not know that their lawyer can't really defend them. They do not really know that they're pleading guilty when they enter the contract with TIK before they ever talk to a lawyer. This is unauthorized practice of law, and this court should grant the Florida Bar's motion for summary judgment, or if you think there's a question of fact, remand it to the trial court for further evidentiary hearings. Thank you.